Greetings and welcome back. In the last mini lecture, I gave you some definitions, powers of government. And the reason that that's so essential with federalism is because that's essentially what federalism is. It is a tug of war. It is a power struggle between the national government and the states. And the Constitution is somewhat ambiguous. Parts of the Constitution tend to support this notion that the national government does indeed have vast implied powers, which is what your textbook authors believe. There are other parts of the Constitution, however, that suggest that perhaps the unresolved parts of the Constitution, the unresolved powers, may in fact belong to the states, and both the national government and the states struggle for political power. And of course, remember, that was what the Constitutional Convention was all about, checking power with power and ambition with ambition. And so if you want kind of just a rough battleground for what both the national government and the states are claiming, the national government, in the nation-centered view of federalism, which is what I'm going to talk about in this mini lecture, the nation-centered view of federalism essentially claims that the national government has vast implied powers, that the Constitution gives them these vast implied powers, and that they are the linchpin or the centerpiece of American federalism. Their opponents, the state-centered federalists, are going to argue that the national government has enumerated powers only, or in some cases they may grant that the national government has very limited implied powers. But those implied powers that I discussed last time are really the debate item. People who believe in the supremacy of the national government, who want the national government to be powerful, and again, that is the view of your textbook authors, they're going to claim vast implied powers for the national government. People who do not want the national government to have these vast powers are going to claim that the states are the reservoir of those powers that are not specifically laid out, and they're going to call themselves the state-centered federalists. So today I want to talk about the nation-centered view of federalism. So if you want to follow along once again in your notes, this was the dominant view of American federalism really from about 1819 to 1835, and I have the dates 1801 to 1835 because that is when John Marshall was the Chief Justice of the Supreme Court. John Marshall was a Federalist. Go back to that debate, right, over whether the Constitution should be ratified or not. Remember, the Constitution, the people who wanted the Constitution ratified were the Federalists. The Federalists tended to be the people who wanted a strong national government. They were the people I referred to as the nationalists at the convention. They believed the Articles of Confederation could not be reformed and that you needed a brand new system of government with a much stronger national government. I would rank John Marshall as the greatest Chief Justice in American history in terms of his influence on the court. He was Chief Justice longer than any other Chief Justice, and he is the person who typifies this nation-centered view of federalism. And so he used two constitutional provisions to support his view of the Constitution. The first one puts some stars next to because this one is kind of in the news right now. We in recent years have had a real battle over this notion of the supremacy clause. And so you probably should know it, not just for historical purposes or federalism purposes, but because it is a battleground even today. The supremacy clause in Article 6 is exactly what its name implies. There's nothing tricky about it. It's very straightforward. If you turn to Article 6 of the Constitution, it states simply that federal laws are supreme over conflicting state laws. So, for example, if you've been following the presidential election the last two cycles, you know that there's a candidate, Bernie Sanders, who has proposed, and now I guess Joe Biden, who's the Democratic nominee, has also seconded this, that he's championed a notion that the minimum wage should be raised to $15 an hour. Now, in California, the minimum wage is $12 an hour, but there are places in the United States where the minimum wage is less than $8 an hour. But let's pretend that magically, and I don't think this is going to happen for quite some time, but let's assume that the minimum wage at the federal level was increased to $15 an hour. Well, the federal minimum wage is supreme over conflicting state laws. So in California, our minimum wage is $12. If the feds increase the minimum wage to $15 an hour, we would have to also increase the state minimum wage to $15 an hour. Now, obviously, states can have a higher minimum wage. Our minimum wage is over $4 more per hour than what the federal government requires. So states can have a higher minimum wage, but they cannot have a lower minimum wage. So there is one example of the supremacy clause. Here's another one. When Western states began passing laws that legalize recreational marijuana, with Colorado being the first state, Washington the second, now a variety of states, and you'll notice that most of the early states were in the West, right? Keep in mind that moralistic political culture of the West. They tend to be more innovative. So Western states gave women the right to vote first. In this case, Western states legalized marijuana first. Now, when Barack Obama was president, and I probably should update these notes, I thought I had updated this paragraph, but I haven't. So this paragraph's a little bit old. I apologize. But Barack Obama, when he was president, said there isn't going to be a conflict because we are not going to enforce federal drug law in the case of marijuana. Now, President Trump has kind of gone both ways. He has at times threatened to enforce federal drug law where marijuana is still illegal. And certainly my reading of the Constitution suggests that President Trump could do this. Now, politically, I don't think it's very smart. There has been a significant rethinking of marijuana, at least in the minds of the American people. And I think it would be foolhardy for the president to enforce the federal drug law. But technically, it could be argued that Article 6 is supreme to state law, and therefore those federal drug laws prohibiting recreational marijuana could be enforced by the national government, even though states have told people that this is a legal activity. So, could the national government enforce the dominance of federal law over state laws when it comes to marijuana? My reading of the Constitution, my reading of Article 6 says the federal government would indeed have that right. If I'm advising the national government, I'm saying don't do this. Allow the states to determine this for themselves and stay the heck away from this. And so it's my belief that eventually there's going to come a point where marijuana is legal in so many states that Congress is going to overturn that law, and that federal law, in my opinion, is going to disappear. So people who believe in the nation-centered federalism are going to point to Article 6, that supremacy clause, right? That in this particular case, federal laws are supreme over conflicting state laws. The other area that people who believe in the nation-centered view almost always point to is a provision that I mentioned in the last mini lecture. the necessary and proper clause, Article 1, Section 8. So I mentioned that Article 1, Section 8 is at the heart of congressional power. There are a lot of powers that are very specific that I mentioned, like declaring war, establishing post roads and offices, patents and copyrights, etc. Those are very specific. There are others that you know what they mean, but they're more general, like regulating interstate commerce. There are some that are very general, like promoting general welfare. But then, if you get to the 18th provision, the 18th provision says, and the Congress shall have all the powers that are necessary and proper for carrying into execution the foregoing powers. Now, this is a very vague provision. This is sort of like in Article 2, where it says the executive power shall be vested in the President of the United States. Some presidents have said it's a grant of power, but some presidents have said it's just a title. There has been a huge argument amongst academics about what does that necessary and proper clause mean. Some people claim it's just an enforcement mechanism. It doesn't give the Congress any more power. It just means that the Congress can enforce the earlier powers. In other words, if a state tries to encroach on a power, for example, I don't know, I'll make up a crazy one that would never happen. But let's say the state of California decided that they wanted to establish a brand new system of weights and measures, or the state of California wanted to coin money. Then the national government could, in essence, shut them down and say, no, the Constitution gives those powers to us. We're taking you to court, and the courts would back the national government. So some say it's just an enforcement mechanism, and that's all it means. But other people say that no, that's not true. That what the necessary and proper clause means is that not only do they have the powers that are specifically listed, but they have other powers that are logical and that make sense. And let me illustrate this by kind of guiding you into a discussion of the next mini lecture on McCulloch versus Maryland. And I'm just going to give you the case for implied powers here, and you don't have to agree or disagree. But in this particular case, the argument was, does the U.S. government have the right to charter a Bank of the United States? There is nothing in the Constitution that mentions banking. So it is not an enumerated power. It's not a power that's specifically given to the national government. But it is also not a reserved power. It is not a power that is specifically granted to the states either. So the question in this case is, does the national government have the right to charter banks? Do states have the right to charter banks? Or do both have the right to charter banks? Now, the national government made the claim that they had the right to charter the bank because if you take a look at banking, what is banking? In the minds of the people supporting the national bank, their argument was that banks are little more than the interstate and commercial flow of money. So if you look at Congress, they can coin money. That's enumerated. They can regulate interstate commerce. That is enumerated. And therefore, it's implied they have the right to create a bank because banking is little more than the interstate commercial flow of money. So if the Constitution meant Congress to coin money and regulate interstate commerce, it's logical, it makes sense, it's necessary and proper that Congress would also have the right to charter a national bank. And I'll go specifically into the case of McCulloch versus Maryland in the next mini lecture and give you both sides of that debate in terms of whether the national government should or should not have the right to charter a bank. And we will do that in the next mini lecture. Have a wonderful day, everyone. Take care.